back to the People's Law School, an effort by the Alabama Association for Justice to present to you the best lawyers in America. Our next speaker is Connie Glass. Connie has been practicing law. Says here she set up her firm in '97, but Connie, you're older than that. I mean,
Law degree in '81.
oh yeah, she got her law degree in '81. I knew she was near my
Thank
age.
you, Alan.
Well, her area is elder law, so she's got to have some experience. But she graduated from the University of Alabama twice, and she is only one of 3 certified elder lawyers in Alabama. And Connie knows what she's talking about, and I know that you can all appreciate when I say that, you know, when my own mother was sick and we had to do something with her estate and her, I consulted Connie Glass and she steered us right, and I appreciate it. And so if I ever have a case where it's a little over my head, there are some people who are old and can't afford her, but I'll tell you, it's money well spent because she knows what she's talking about, and you'll be convinced of that here in about 55 minutes. Connie Glass.
Thank you, Alan.
Good to see
Appreciate
you.
it.
Thank you.
Good evening. I'm so glad to be back with y'all at People's Law School. This is always a wonderful event, and I love being able to participate. As you heard, I'm going to talk with you for the next little while about elder law. Elder law is one of the few areas of law that have to do with the people that I serve rather than the type of law that we practice. With criminal law, bankruptcy law, corporate law, those have to do with the type of law. Elder law has to do with a group of people as they age. And that's all of us. All of us are aging. And as we age, our legal needs change. My legal needs have changed from back when I was 29, and I'm about to be 59. And so it's a very different place that I am in my life now. So I'm beginning to look at things differently as far as finances, medical, and my legal issues are different now. We begin to, as we age, look more at where we're going to be in retirement, where we are as far as our medical needs. Do we have the resources to pay for those times in the future when we may not be as able to do things as we are now? So those are the kind of things that elder law addresses. What's going to happen to us and what's going to happen to our stuff as we get older and as we can't manage for ourselves in the future. So what I want to spend a good deal of time talking with you tonight about is long-term care. As we get older, unfortunately, we don't always stay as healthy as we are now. So we have to look at what is available to us as far as caring for us, whether it be in our home or in a facility. What's out there? What kind of care is available to help us, and how are we going to pay for it? Are we going to be able to afford to pay for it out of pocket? Do we need to look at insurance to cover that cost? Or is there a government assistance program that's going to help us and be there for us if we need that level of care in the future? So that's what we're going to talk about tonight mainly. So I want to start out by just elaborating a little bit on what Alan said about me. You heard that I opened the elder law firm in 1997. Prior to that, I was working at the Area Agency on Aging. I was the attorney there for 10 years. So I've been in the field of elder law for not quite 30 years. Became certified in elder law, and what that means for you is simply that certified elder law attorneys have to take an additional exam, very similar to the bar exam, which I swore I'd never do after I took the first one, but I did. And then every 5 years, I have to be recertified in the area of elder law. I have to certify to the National Elder Law Foundation that I'm still practicing in this field. I have to have 15 hours of continuing education every year in the field of elder law, so that I can retain my certification as an elder law attorney. So if you're looking at elder law attorneys in other states and other areas, that's probably one of the first things you want to look at to see if there's a certified elder law attorney in that area. All right, let's jump into our subject matter. Long-term care. Obviously, it is what it says it is. It's care that's going to be provided to you on a long-term basis. Long-term care is not you break your leg, you're in a cast for a few weeks or months, and then you get better. Long-term care is either a chronic condition or some condition that's going to cause you to need care on a long-term basis. Usually when you need long-term care, it's the beginning of a period of your life where you're probably not going to get better from whatever the condition is. So what's available to you as far as long-term care? And of course you can be cared for in the home. Long-term care always can be provided in your home setting if you have the resources to do that. You know, if you just need a few hours a day of care, many of us could pay for that. When you begin to need 12, 14, 18 hours, 24 hours a day care at home, that becomes the most expensive kind of care you can receive because it's a one-on-one caregiver with you. So when you're looking at paying $16 to $18 an hour for a 24-hour-a-day caregiver, it begins to be out of the reach of most of us. So most of us are not able to stay at home once we need that 24-hour-a-day, 7-day-a-week care. So what else is available as far as long-term care settings? Alabama has what's called assisted living facilities. Assisted living facilities are those licensed facilities that provide just what they say, assistance with daily activities of living. The Alabama Department of Public Health licenses these types of facilities, and they generally provide room and board, they provide meals, housekeeping service, assistance with activities of daily living. They can provide some medication assistance, and it's great for socialization, transportation. When you can't live at home anymore, whether it's due to illness or you're just not comfortable living at home anymore, assisted living is a great place to transition to out of your home. When you can't be as independent as you were living at home, assisted living is a great opportunity for a somewhat independent but a monitored home setting. Several years ago, we realized that people were being forced out of assisted livings into nursing homes really prematurely because of cognitive issues. So many years ago, or several years ago, Alabama started licensing what's called specialty care assisted living facilities, which are specialized facilities for people with cognitive impairment, dementia, Alzheimer's, any sort of cognitive issue which prevented them from being safely cared for in assisted living. They could be in the specialty care assisted living. There's additional training, additional staffing at these kinds of facilities, so obviously the cost is a little bit higher at the specialty care assisted living facilities, but it may not be as high as around-the-clock nursing care at home or nursing home care. Again, it's a more home-like setting than a nursing home setting. You don't really need nursing home care, but you need that round-the-clock care. When you can't live in an assisted living facility or you can't afford assisted living facility care anymore, then you can move into the nursing home setting. And the nursing homes in Alabama are licensed again by the Alabama Department of Public Health, and they're the only kind of facilities that provide round-the-clock nursing care on a long-term basis. Nursing homes are the only level of care in any of the ones I've discussed where you can get government assistance to help pay for your care when you don't have the means to pay for it yourself. And we're going to talk about that in just a minute, about what's available as far as paying for nursing home care. In Alabama, there are also veterans nursing homes, which are kind of a unique area of nursing home care. There are 4 in Alabama. There's one in Huntsville, one in Bay Minette, one in Pell City, and one in Alexander City. Those are for veterans, and the care is provided through the Veterans Administration, or it's financed through the Veterans Administration. So those are unique to veterans, and with most of those veterans nursing homes, because there are so many more veterans that need care than there are beds, there's a waiting list at most of those veterans nursing homes. In a nursing home in Alabama, other than the veterans nursing homes, you have to either be able to pay your own way, either through financing yourself, being able to write the check. You have to have long-term care insurance that covers it, or if the facility accepts Medicaid, you have to be able to qualify for Medicaid assistance. Nursing homes in Alabama run anywhere from $5,000 to $6,000 a month, upwards of $9,000 a month. We have a nursing home here in Madison County that just went up to about $9,000 a month. Most of us can't write a check for very long to nursing homes at that rate until we're out of resources. So then what do? Are they going to kick you to the curb? Do you have to leave? What's going to happen to you? That's when you have to have some other source to pay the bill, when you don't have the ability to write a check and pay the bill. Some people take advantage of long-term care insurance. You have to have that kind of insurance before you have the need. So you can't wait till you're going into a nursing home or in a nursing home to buy this kind of insurance. You already have to have it because the eligibility for long-term care insurance is dependent on your age and your health. You have to be relatively healthy, and you have to be at an age where you can afford the premiums, because the premiums are based on age and health. So when my clients come in their 50s or their 60s for long-term care planning, one of the things you want to look at is, am I in a position where I can afford long-term care insurance, and am I eligible to get am I insurable? Can I get long-term care insurance? So it's something you definitely need to look at if you want to have choices about what kind of care you receive, and if you want to protect your assets from having to use those assets to pay for nursing home care. I call it asset protection insurance. Long-term care insurance most often is purchased to protect your estate, to save your money, your property, your things from having to be liquidated and used to write a check and pay the nursing home for a length of time. So if you are in that age group where you're still relatively healthy, you're still relatively young, you might want to look at long-term care insurance. It's great insurance to have if you can afford it. A lot of folks think that Medicare, Social Security or Medicare, pay for long-term care. Medicare does not cover long-term care either at home or in the nursing home. Medicare is for acute care, for short-term care, for illnesses. It's health insurance. It's not long-term care insurance. So Medicare will pay if you get sick and go to the doctor, if you get sick and go to the hospital. It'll pay for short-term stays in the nursing home. But the maximum amount of coverage you can get for a nursing home stay is 100 days. Of that 100 days, Medicare only pays fully for the first 20. From days 21 through 100, then Medicare pays after the patient pays a copay of $161 a day. So if you have insurance that covers your $161, you can get 100 days of coverage. But if your health insurance that you have to supplement your Medicare doesn't cover those copays, that 80-day copay period, then that's out of pocket to you at $161 a day, up to the 100 days. After 100 days, then Medicare doesn't cover your stay anymore in the nursing home. You either, at that point, you go home, you've rehabbed enough and you're well enough to go home, or you have to move over into long-term care. And that's where the bill's going to run somewhere around $200, $250 a day, sometimes $280 to $300 a day, depending on the facility. So that's where you got to have the ability to pay. It can be as much as $9,000 or $10,000. Some nursing homes in this area still are around the $5,800 to $6,000 a month. We've only got a very few that are over that $8,000 or $9,000 area. If you have to stay long-term and you run out of the assets and don't have the ability to pay for the nursing home, then your option is to apply for Medicaid assistance. Medicaid is a government assistance program that can assist you with long-term care in the nursing home. Medicaid is a needs-based program. You have to qualify for Medicaid. So there's an income test and there's a resource test, and we're going to talk about both of those. Medicaid is a federally and state financed program, mostly federal dollars, and there are federal regulations and there's state regulations. So what that means for you as a consumer is that every state's Medicaid program is a little bit different. There's an umbrella of federal regulations that everyone has to meet, but within those federal regulations, states have the leeway to manage their program as long as it's no more restrictive than the federal regulations. So you could be eligible for Medicaid in Alabama, but not be eligible for Medicaid in Tennessee. You could be eligible for Medicaid in Ohio, but not in Alabama. So when you move from state to state, you're not necessarily, just because you're on Medicaid in one state, you're not necessarily going to be on Medicaid in the nursing home in another state. I had that happen to a client of mine one time. His parents were living in Illinois. His dad passed away. His mom was on Medicaid in the nursing home there. He moved her to Alabama to be closer to him. The nursing home said, "Oh, don't worry, you're going to be on Medicaid. You were on Medicaid up there." 6 months later, he got his denial, and she was not on Medicaid, had not been eligible for Medicaid for that entire 6 months since the application was pending. So he came to me with a 6-month nursing home bill going, "I don't know what to do. How am I going to get mom qualified?" So it was just an assumption that just because she was eligible there, she'd be eligible here, and you just can't make that assumption. Being that I live in North Alabama, of course, we have people that go across the state line to Tennessee to go into a nursing home there. There may not be availability here, so they move to Tennessee to be in a nursing home. And they may be getting advice about Alabama Medicaid, but not realizing, whoever's giving them that advice doesn't realize that they're not giving them correct advice for the state of Tennessee. So you have to be very careful. It's very state specific when you're talking about Medicaid. So what I'm telling you tonight has to do with Alabama Medicaid, right? A lot of folks will tell me, "Well, I don't want to be on Medicaid." That's great. You don't have to be, but if you go to the nursing home, you got to be able to write a check for $6,000 to $8,000 a month. If you can do that, you don't have to be on Medicaid. Nobody cares that whether you're on Medicaid or not, as long as you can pay the bill. Many people go into the nursing home never intending to be on Medicaid, but about 70% of all nursing home residents are on Medicaid. Almost 3/4 of the nursing home residents in Alabama are on Medicaid. These are not the poorest of the poor. They didn't start out that way, but they go to the nursing home and they write checks until their money is gone and they're still there, and they have no choice but to apply for Medicaid assistance. So it may not be something that we want, but it may be something that happens. So it's very important for you to understand how Medicaid works in the nursing home. There's a lot of misconception about how Medicaid works. All right, in order to qualify for Medicaid, you have to meet 2 tests. We're going to talk about the easier one first. It's the income test. If your income, your personal income, retirement, Social Security, whatever you get regularly on a monthly basis, is more than $2,199 a month, you don't qualify for Medicaid in the nursing home. So
About $2,200 a month.
$2,199 a month. So what do? What happens? You can't pay a nursing home bill with $2,200 a month. So what do? There's a way that we can make you income eligible for Medicaid. I'm going to explain it to you, but you don't have to remember it because it won't make any sense. It's a weird little glitch in the law that says if your income's over the income limit in an income cap state, and Alabama happens to be an income cap state, then you can create what's called a qualified income trust. Now, it's not a trust like any trust that you've ever seen or known about or heard about, or a trust that you may have. It's not truly a trust, but it is. So you create an income trust. The trustee of your trust takes that trust document down to a bank and opens up a new account. It's called a qualified income trust account. The only thing that goes into that account is your income. The minute your income goes into that income trust account, you don't have it anymore because it's out of your control, under the control of this trustee, whomever this person is, your family member, whomever. So your income is zero. Voila, magic. You're under the income limit for Medicaid. Now, what happens to the income in the income trust? It gets paid to the nursing home just like it would if it had never gone into the income trust. So it's income in, income out to the nursing home. But if your income's over the limit and you don't do this little weird income trust, you don't qualify for Medicaid. Alabama has the option of abolishing the income cap, but they've chosen not to do that. So we are an income cap state and have to have an income trust. I can't tell you why. I can't tell you that it makes any sense, but just know if you're over the income limit and you're in the nursing home and you're close to qualifying for Medicaid, you have to have an income trust to qualify. Met with a lady today. Her aunt's in the nursing home, went in at the end of December. She lost the month of January, her aunt did, because we didn't do the income trust. So we've got until Friday to get the income trust done so that February's income can go in there and we can get her on Medicaid. Nobody told her that there was a way to fix the income problem. All she was told is, sorry, she's over the income limit, she doesn't qualify for Medicaid. Income is never a barrier to qualifying for Medicaid. That's all you got to take away from this. Income is not a barrier. It's a fixable issue. We can always fix the income issue. All right. Yes, ma'am.
Does income include revenues from annuities, IRAs, other investments?
There's an easy answer to that question. The question is, does income include revenue from IRAs, annuities, investments? In order to qualify for Medicaid, you're not going to have those because we're about to talk about resources, okay? The other prong of the test, there's the income test and then there's the resource test. The income test is the easy part. Now let's talk about resources. If you are a single person and you go to a nursing home, if you've never been married, if you're married and divorced, if your husband or wife has died and you don't have a spouse living and you go to a nursing home, all of your countable resources, IRAs, annuities, stocks, bonds, CDs, everything you own has to be spent down to $2,000 or less before you can qualify for Medicaid.
And you're not talking about monthly, you're talking.
Assets.
Aggregate, like
Yes.
only 2,000.
I'm not talking about income anymore. Not income, not your checks, but your checking and your savings and your CD and your IRA and your annuity, your life insurance that has cash value.
The aggregate of the resources.
The aggregate of your resources has to be $2,000 or less in order to qualify for Medicaid.
What about houses or included?
The house is included if you are a single person. Okay? So if there's not a spouse or a dependent child living in your home, then your house is a countable asset. And it either has to be liquidated or it has to fall under the one of the exceptions about not having to liquidate it. But even if it falls under one of the exceptions that Medicaid's not making you sell it, they're probably taking a lien against it for what Medicaid pays out.
My house is in the name of me and my son.
Okay, we're going to talk about, to hold that thought, because we're going to talk about transfers in just a few minutes. But right now, just resources. If you go to the nursing home and you own a piece of property, you own a piece of property with someone else. Let's say Alan and I own a piece of property together. I have a half interest in that property, so my half interest is a countable asset. So any interest I have in real estate that can be liquidated is a countable asset.
What
If
about inheritance? Do you have inheritance? If you have property and inheritance that like, can they take that too?
Okay, the question is, what about an inheritance? Inheritance is nothing but assets. If you have assets, they're countable. It doesn't matter where you got them from. It doesn't matter if somebody gave them to you, if you inherited them from Mama, if you inherited them from Aunt Susie, if you got them in your divorce settlement. If you have assets, they are countable. Now, someone said, can they take them? The nursing home doesn't take anything. Medicaid doesn't take anything. You are paying the nursing home bill with your assets. So when you go to a nursing home, you don't turn over your assets to the nursing home. You don't sign things over to the nursing home. Every month that you're there, they're going to send you a bill. So if you go to the nursing home and you're going to be there for February, you're going to get a bill in the mail this week. And it's going to tell you the cost for February is $6,000. So if you want to stay for February, you write them a check for $6,000. If you're still there come March, they're going to send you another bill. So you don't give them your stuff. You don't turn over things. That's a very common misconception about nursing homes, that in some fashion you have to hand over your stuff to the nursing home. You are paying for that bed you're sleeping in every night. That's what it's like renting a room. It's like renting an apartment. It's like renting a hotel room. You are paying for the time that you're in that bed. So every month that you're there, you got to pay for that bed and that care that you're receiving. When you have a parent, a relative, somebody who goes to a nursing home, they don't take your stuff. You pay for the service that you're getting. You pay once a month for the service that you're getting. If you don't pay, they don't keep you. You get an eviction notice.
Let's say that a person is going into the nursing home. They have a mobile home and no other real assets. Social Security, $1,000 a month or so, which seems to be the standard. Now, they go into the nursing home, they're not eligible for Medicaid because they have a $30,000 mobile home. But yet they don't have the assets to pay for it. You mentioned that they would put a lien against the property.
Not against a mobile home. Mobile home's not real property. You can't take a lien. Medicaid cannot take a lien against a mobile home. It's like taking a lien on a car. Medicaid doesn't take a lien on a car.
They'd have to sell the mobile home.
The nursing home resident, if he or she goes into a nursing home and owns a mobile home, and they don't own the land it sits on, they just own the mobile home, they'll have to sell that mobile home and use it to pay the bill.
But if they can't sell it, that's where I'm going, is it takes the time to sell it. They're in the nursing home
With no way to pay the bill.
with no way to pay the bill, but they've got a mobile home and or the land that it sits on.
The land that it sits on is a different matter. If you've got a piece of land, as long as that land's listed for sale, Medicaid can take a lien on that land. But they can't take a lien on a mobile home. So they can take a lien on the land. There are people who are in a quandary because they can't liquidate things fast enough. You go into the nursing home and you've got $50,000 worth of stock, and you wait till you're in the nursing home and all of a sudden your family realizes, oh my gosh, we've got to sell the stock, and it takes the stock company 30 or 40 days to get you a check. You got a nursing home bill that's building up. You're not qualifying for Medicaid while that stock is still there and you own it. So you need to plan ahead when you've got a family member, if you can, unless it's crisis, when you've got a family member going into a nursing home. Rental properties, a biggie. We don't encourage our older clients to stay in rental properties because those are sometimes very hard to sell when they're going into a nursing home. So it's always good to, when you begin to age, you want to simplify your estate so that as much as possible it can be liquidated pretty quickly if you're going to need it. All right, let me jump real quickly. I know we've been talking about single people. Let me jump to married couples because the rules are different for married couples. If you're single, all of your assets have to be liquidated and spent down to $2,000. And spending down means generally writing a check to the nursing home, okay? If you're a married person, if you go into the nursing home and you have a spouse still at home, the spouse at home gets to keep the home, a vehicle, and generally 1/2 of everything else, up to a maximum of $119,220. So let me give you an example. You got a married couple. They've got $100,000 in the bank. They got a house and a car. Husband goes to the nursing home. Wife's still at home. She gets to keep the house, no lien, Medicaid ignores it. She gets to keep the car, she gets to keep everything in the house, and she gets to keep half of that $100,000. The husband spends his $50,000 on the nursing home until such time as he's spent it, and then they can apply for Medicaid for him. Now let's say this same couple has $300,000. Half of that's $150,000. That's more than the maximum. The maximum is $119,220. So wife at home gets to keep $119,220, and everything in excess of that has to be spent on the spouse in the nursing home. Okay? And that number adjusts a little bit every year. So if you've heard that if your spouse goes to the nursing home, you've got to spend everything before they can be on Medicaid, or you've got to be penniless before they can be on Medicaid, that's simply just not true. There's always some portion of the assets the spouse at home is going to get to keep. And as long as that spouse at home is living in the house, it's just excluded. Medicaid acts like it's not even there. They ignore it. They don't take a lien, they just simply ignore it, as long as your spouse is living in it.
I've heard of cases where the spouse that's still healthy gets a divorce in order to save the assets.
Okay, she mentioned people getting a divorce in order to save the assets. I've been doing elder law since 1987, and I have never, ever had a case where a spouse got a divorce to protect assets. Spouses are just not interested in divorcing their spouse who's going to the nursing home. I'm not telling you it doesn't happen, but I've been doing this for 30 years, and I've never had a client who's interested in divorcing their spouse to save money.
You mentioned house, car, and banking account. House, car, banking account, and a vacation condo in a different state.
That's just an asset. If the spouse, let's say a couple has a home, a car, $100,000 in the bank, and a $100,000 condominium in Tennessee, in Gatlinburg, okay? So they have $200,000 in countable assets. They have $100,000 in cash, and they have a $100,000 vacation home. So the spouse at home is going to get to keep half of that, $200,000. The spouse at home gets to keep $100,000 worth of assets. So if that spouse at home wants to keep the condo in Tennessee and spend all the cash on the nursing home, she can certainly do that. Medicaid doesn't say that you have to spend half of every asset. It's half of the total. So the spouse at home gets to pick and choose which of the assets he or she wants to keep.
Do they look in arrears any? So like we got the house, the condo situation, and you realize that one of the, maybe my wife has got to go in, quit claim deed, give the condo to the kids.
Everybody wants to talk about transfers. So that was your question, that's your question. So let's talk about transfers. The question is, can you sign that quitclaim deed and give away that condo right before your wife goes in the nursing home? When you apply for Medicaid assistance, Medicaid looks back in your financial history for 60 months. So when you file the Medicaid application, you have to provide to Medicaid as an applicant 60 months, 5 years worth of financial records. They want to know what you've owned in that 5 years and what you've done with that stuff. So you have to provide them copies of bank statement, copies of checks, if you've cashed in CDs, if you've cashed in IRAs, if you've given away property, if you've sold property, if you've sold a car, if you've sold stock, anything you've done in that 5 years, Medicaid wants to know what you've done with it. If within that 5 years, that 60 months of applying, you have given away or transferred something for less than its value, if you've sold it for less than its value, then Medicaid adds those dollars up, and they're not going to pay for as long as that would have lasted you in the nursing home. Okay? That's the transfer penalty that everybody hears about.
Okay, I'm a little.
Then it's value. If you had a $5,000 car and you gave it to the Downtown Rescue Mission, okay, if you have a $10,000 car and you give it to the Downtown Rescue Mission, you've given away $10,000 that you could have otherwise used to pay your nursing home bill. So
If you could have sold the vehicle.
well, you could have sold it. If it was worth $10,000, somebody's going, doesn't matter. It's a $10,000 vehicle. Medicaid's going to penalize you for it. Anything that you give away. If I have a client right now who has for the last 5 years, well, longer than 5 years, been giving their grandchild $500 a month just because they love them, that's a transfer. So we're going to have to add up 60 months worth of $500 a month, and Medicaid won't pay for that long in the nursing home. That's their penalty. Nobody cares what you give away. Medicaid doesn't care what you give away. You can do it. I have clients tell me all the time, well, Medicaid can't tell me what I can give away. Absolutely not. They can't tell you what you can give away. You can give away anything you want to, anytime you want to. It's up to you. But you can't give it away and then ask the government to pay your nursing home bill if it's within 60 months. That's the way the rules work.
Is the 60-month thing part of the federal or part of the?
60-month is a federal rule.
Has that 60-month standard been around for a long time?
It has been the rule since 2006. The 60 months has been the rule since 2006. When I first started practicing in elder law, almost 30 years ago, it was 2 years. It went from 2 years to 2.5, went from 2.5 to 3, and from 3 to 5. So it's been, the look back period has been 5 years, 60 months since February of 2006. Okay? All right, so that's the transfer rule. So what does that mean for folks? That means that, unfortunately, we've got to be cautious about giving our property to our kids, giving our property to our kids, and even retaining a life estate. I have a lot of clients who want to give their property to their kids and retain the right to live there. It's perfectly fine. You can do that. It's no problem. Maybe a problem, but you have every right to do it. But then if you go to the nursing home within 2 or 3 years, you don't have a way to pay your bill unless you've got some other source of money to pay it with. And everybody says, oh, well, the kids will give it back. They might. They might not. But what if one of your kids has died and all of a sudden their interest in that property passes to their wife or their husband, and they've already remarried and they've moved away? They have no incentive to give that property back to you just because you're in the nursing home. They don't really care necessarily. Or what if your child to whom you've given that property dies and they're survived by minor children, and all of a sudden you've got minor children who own that property? Minor children can't consent to give it back to you. You're in a world of hurt. So before you just rush down to the lawyer and willy-nilly give your property away, you need to have a plan on how you're going to pay for your care for the next 5 years. Let's say you've got long-term care insurance. If you've got long-term care insurance to pay for 5 years, heck, you can give away anything you want to because you got insurance to cover your need for the next 5 years. But if you've got $10,000 in the bank and you give away your house, you can pay for a nursing home for about a month and a half. So what you going to do with the other 58 months that you can't pay for? Yes?
So you're saying if you do a life estate, you better have done that more than 5 years before you go into.
Yes. So what I'm saying is, if you transfer your property reserving a life estate, if it's been more than 5 years, you just don't have to report that on a Medicaid application because they don't care if you gave it away 6 years ago. They don't care if you gave it away 5 years and 3 months ago. But if you gave it away 4.5 years ago, you got a problem. Okay?
Connie, is it a one-time look at your status by the government? Or do they continue to monitor?
That's a great question. The question is it a one-time look, or do they monitor you even once you're on Medicaid? The look-back period of 5 years is a one-time when you apply, okay? Every year that you are on Medicaid, you have to do an annual review. So let's say you've got a couple. We got the house, the car, and the money. Mama's at home, daddy's in the nursing home. Daddy has gotten on Medicaid. Let's say he spent whatever dollars he's got to do to get on Medicaid. And mama at home goes, whew. And then 2 or 3 months later, the kids start telling her, well, gosh, we got to go get everything out of your name, because if you get sick and go to the nursing home, we don't want to have to do what we just did for daddy. So she goes to the lawyer, and the lawyer deeds the house away, and she moves all the money over to the kids. And it comes time for daddy's annual review, and she's given her stuff away that was hers. Guess what? Daddy just got cut off Medicaid because it's protected for her, not for her kids. So in essence, Medicaid does review not for 5 years, but from year to year, you have to prove to them that you are still eligible for Medicaid, that you still meet the requirements to qualify for Medicaid. And if you make transfers, you are not eligible because of the transfer penalty. Absolutely.
Because I'm sure somebody else has thought about this, and I know I'm missing something, but let's say getting to a point where your spouse may need nursing care, convert your house to a nursing home, little LLC?
No, that's a good question. If your spouse needed nursing home, can you convert your home into a nursing home? You're not going to get licensed by the Alabama Department of Public
Well,
Health.
there's certain real tough criteria.
Oh, absolutely,
Okay,
yes,
all right.
yes. Your home will never be licensed as a nursing home, I can promise you.
If a
Let me
nursing
get you-
home patient has no more relatives
Mm-hmm.
and runs out of money, can the nursing home actually evict that person and become a?
That's an excellent question. If a person runs out of money and they don't have somebody who's going to apply for Medicaid for them, or they apply for Medicaid and there's a transfer penalty assessed and the nursing home's not getting paid, are they really going to take them out, put them in the wheelchair, and put them on the street? Of course they don't. They can't do that. What happens practically is that the person's going to get sick and they're going to need to go to the hospital. And then they go to the hospital and the nursing home says, sorry, they can't come back. There's a bill, they're not paying, and so they can't come back here. So then the hospital gets stuck with them trying to place them. Then what happens? Hospital's going to call the Department of Human Resources, Adult Protective Services. Adult Protective Services is going to file with the court and make them an adult in need of protection. And then they're going to have to shop around and find a place that's going to be able to afford to take them until they can get on Medicaid. So that's what happens, practically.
Say that spouse living at home dies before the person in the nursing,
Great question.
and they've got a $200,000 life insurance policy to the person in the nursing home. That money comes to them, they come off of the government assistance, and they gotta spend it down to go back on government assistance.
Question is, your wife is in the nursing home. She's on you got her on Medicaid. And then you pass away first. You're not in the nursing home and you're at home and you pass away first. And you have a life insurance policy that pays to your spouse in the nursing home. Well, if you've done that, you're not my client because I would never let you do that. I would have had you change the beneficiary on your life insurance policy to someone other than your spouse. I would have also gotten the property deeded over into the spouse at home's name so that we can do a will that protects it from having to go right back to the spouse at home. So when you get your spouse on Medicaid in the nursing home, that's step one. Then you've got to do all the estate planning to ensure that if you die first, they just don't come right off Medicaid. But in those people who are not my clients, who have not done it correctly, that's exactly what happens. It could be a house that's owned jointly. So mom's in the nursing home, dad's at home, dad dies first, there's a jointly owned property, all of a sudden it's empty and it's mama's. She comes off Medicaid, that house has to get sold, used to pay her bill, till it's all spent, down to $2,000, and then she can go back on Medicaid. Or there's a life insurance policy, or there's still a joint bank account, or there's something that automatically goes to mama. I had some clients recently that we had gotten mama on Medicaid, and we advised them how to get everything out of mama's name, get it over in daddy's name, pay on death or transfer on death to one of the kids. They did that, all except one bank account. It's got $6,000 in it, and now mom's going to come off because now that money's going to go to her. She's coming off Medicaid for 1 month till we spend down that $6,000, and then we got to reapply for the next month. So it can just be one little thing that people forget to do, which can take the spouse off Medicaid.
Let's say you have a husband who qualifies for Medicaid, and there's a $320,000 house at home, and then suddenly the healthy wife decides she wants to downsize, maybe get her a $120,000 condo somewhere, and so she just wants to sell the $320,000 house. How do you do that to protect your asset?
You don't. Question is, there's a $300,000 house. We've gotten daddy on the husband in the nursing homes on Medicaid. Mom says, I can't keep up this $300,000 house anymore. I need a $150,000 house. So I'm going to sell my $300,000 house and buy a $150,000 house and just put my $150,000 in the bank. Daddy's coming off Medicaid when mama does that, because now there's another $150,000 that goes back in the initial assessment and has to be split according to the assessment rules. So unless you take,
Whom? Oh,
I'm
you
sorry?
said split, 150
But-
split between whom?
well, it may or may not, so all of it could end up going to the spouse in the nursing home. It depends on what they started with initially. So it's whoever's in the nursing home's coming off Medicaid. So what I always tell mama is, you can downsize, but you got to stay at the same amount of money. If you're selling a $300,000 house, you can buy a smaller one, but it's still got to be a $300,000 house, or else you're going to have to stay there.
Connie, going back to Alan's question, you had the $300,000 house, she wants to downsize, but earlier you said that she could change the title into her name,
Yes.
and therefore then she could downsize, according to what I'm understanding.
Even if the house is in her name only, if the house is sold, Medicaid looks at assets that are available to either spouse, and dollars are available. A house is not available, dollars are available. So those do count. You had a
Did you say
question?
every time that you come off of Medicare, for whatever financial reason, you have to reapply?
Yeah, and the question is, every time you come off, do you have to reapply? When it's only a month, we actually don't do a full reapplication. Medicaid can block payment for a month. So if I know that I've got a client that's going to come off in March, I notify Medicaid, they'll block payment for March, and I can show them that she'll be eligible again in April. So I can work with them so we don't actually have to do a full reapplication, particularly if it's a short time.
Don't nursing homes themselves help with that application? Don't they get very much involved because it's in their interest?
No, they do not get very much involved. The question is, don't nursing homes help with applications? The nursing home will fill out the application. That's what they do. That's all they do. Once they fill out the application, then it's you. You correspond with Medicaid, you provide Medicaid records, you deal with Medicaid, you deal with the penalty, you talk to Medicaid, you provide them what they need. The nursing home doesn't, they fill out the application. You can do that yourself. What you need someone to assist you with is knowing what to send to Medicaid, knowing what Medicaid needs, knowing what they can ask for, knowing what they can't ask for, knowing the problems going in. When we do a Medicaid application, I can tell you going in if there's going to be a problem with it, because I've already been through the records. I've been through 5 years worth of records. When the nursing home has you send in an application, they'll tell you, send in 3 months worth. Okay, you do that, the first request you're going to get from Medicaid is, I need to see 5 years worth. And they give you 20 days to provide that. You don't want 20 days to have to come up with 5 years worth of bank records. You can't get them in 20 days if you're going to have to get them from the bank. So what you're getting help with is a process that's totally foreign to you. If you've never applied for Medicaid, it's just a foreign process. And it bears no resemblance to common sense, I can tell you that. I've just scratched the surface of the rules tonight. I hadn't even talked about funeral and burial and how insurance interplays with funeral and burial. The funeral home will tell you you can have $5,000 worth of assets set aside for funeral and burial. Well, you can, but not really. You can have more than $5,000 set aside for funeral and burial, but not if you've got life insurance that has a cash value. But if the cash value is more than $5,000, they count the cash. If the face is more than $5,000, they count the cash value. If the face is less than $5,000, they count the face value. So you see how complicated it gets really fast. Before I run out of time, thank you for your questions, by the way. They were excellent, and I appreciate your interest in all this. And before I run out of time, I always end by reading a very delightful little poem that's called Warning by Jenny Joseph. Those of you who've been here before have heard me do this. This is the way I want to be when I get older. And you notice I didn't say old because I'm almost there, but when I get older, I want to be like this. It's called Warning, and the author's name's Jenny Joseph. When I am an old woman, I shall wear purple with a red hat that doesn't go and doesn't suit me. And I shall spend my pension on brandy and summer gloves and satin sandals and say, we've no money for butter. I shall sit down on the pavement when I'm tired and gobble up samples in shops and press alarm bells and run my stick along the public railings and make up for the sobriety of my youth. I shall go out in my slippers in the rain and pick the flowers in other people's gardens and learn to spit. You can wear terrible shirts and grow more fat and eat 3 pounds of sausages at a go, or only bread and pickle for a week and hoard pens and pencils and beer mats and things in boxes. But now we must have clothes that keep us dry and pay our rent and not swear in the street and set a good example for the children. We will have friends to dinner and read the papers, but maybe I ought to practice a little now, so people who know me are not too shocked and surprised when suddenly I am old and start to wear purple. Thank you.
So your question is, what does it mean when the judge says to your objection, he says overruled? That means you didn't win. If he says sustained, that means you're doing good, and then the other side can't do what they wanted to do in your case. But you know, we were talking about judges. George and I were a little while ago, and we were talking about judges' latest rulings. You know, stare decisis, things like that. What does all that mean? And it means the latest ruling in a particular case is what the judge is supposed to do in your case, if it's an identical case. And so we were arguing this case one time, and I kept saying, Judge, but this and this, and this is what you must do, and whatever. He went, bam! He said, Alan, I just overruled you. You got anything later than that? So those are the kinds of things you put up with. And I always think about the Charlie Hooper moment when he was a prosecutor and somebody like Phil was the defense attorney, and the drug addict had not done what he was supposed to do prior to trial. He had stayed on his drugs or whatnot. And so Charlie Hooper said, well, I'm just going to reluctantly, I know I said I would recommend probation, but I'm just going to reluctantly recommend probation. And Judge Snodgrass looked at him and he said, well, I'm just going to reluctantly grant it.
Would take a case on a contingency fee basis, and typically that's a case where a person has money that they believe that they're entitled to. Cases such as a collections case, a car wreck case, medical malpractice case. Those are the types of cases that you can take under a contingency fee basis. There are different types of cases, for example, in an alimony or a child support type case where you cannot take a contingency fee based on what you recover, but instead you would work by the hour. Contingency fees can range anywhere between typically a third up into about a half of the total recovery. There are certain cases that you'll hear about, for example, Social Security disability, that have limited fees where the attorney can only recover 25% of whatever they've collected on the back pay, or even in a workers' compensation case where they're limited to 15%. And some of that's governed by statute as well as other applicable law. The question is that in a multiple plaintiff claim or a class action lawsuit, it sounds like the injured party doesn't receive as much money. However, the injured party in a case such as what you described, let's say a videotape return agency, back when VCR tapes were popular, there were late fees that were assessed and things of that sort. And although the individual consumer only received a small portion of what the total settlement was, there were a lot of lawyers and a lot of hours that went into that, along with expenses that go along into the prosecution of claim.
And
So,
it stopped the criminal action.
and it did stop the bad act. It may not have been criminal per se, but it did stop the bad action. And so that's one of the reasons why we have attorney's fees, is because frankly the government can't babysit all the bad actions that go on in society. And so fortunately we do have lawyers that can go out there and fight for the individual person.
Is all the evidence in a criminal case admissible in a later civil case? Yes. The answer is no. No, and it's because there are different burdens of proof. And there are different standards and there are different parties You have the state versus the defendant versus somebody else versus the defendant in a civil case. And the burdens of proof are different. They're different trials. And I will also tell you, having seen several cases tried twice, like a guy gets charged with robbery, murder, he gets convicted, later the case is overturned in the Supreme Court of Alabama, comes back, it's tried again. I've done this. You don't even recognize the case the second time around. Or paternity cases, the jury hangs up the first time, they can't figure out whether he's guilty or not of being the father of the child. That used to happen often before DNA a long time ago. And you try it again, and it can't be brought up. The prior jury verdict cannot be brought up to the second jury.